We just had a 4-4 tie, a deadlock at the United States Supreme Court. But why? And what will Amy Coney Barrett do the next time the religious charter school issue comes up to the United States Supreme Court? And it's coming up. Oklahoma and its governor has already said, we're not sitting down for this one. We're bringing another case to the U.S. Supreme Court. And that's not the only one. There's going to be cases from Texas and Louisiana. They're going to flood the zone up to the United States Supreme Court to make them make a decision, this time with Amy Coney Barrett. Why wasn't she there for this decision? There's a very good reason. I'm going to describe it to you with my colleague, Dina Doll, on Unprecedented. And here's a clip. Let's jump into charter. Yeah. Speaking of religion and faith, let's talk about the charter school, just to frame it, then I'll turn it over to you. Oklahoma and its Supreme Court made a decision, a year or so ago, that the federal funds going to a religious organization that ran a charter school was a violation of church and state, was a violation of the First Amendment, the Establishment Clause of the First Amendment. There's always this battle with the right, MAGA right, about they only want to read the free exercise clause of the First Amendment. They never want to read the clause related to establishment. So in other words, they want to argue, we need to be able to freely exercise our religion. And to do that, we need your money. We need federal dollars to do that. And we always say, no, if you need federal dollars to do that, then that's the government establishing a religion. And that is the separation of church and state. But of course, this Supreme Court over the last 5-6 years has just, chipped away at is an understatement. Removed brick by brick the wall separating church and state. So there's basically one brick left. And now that was this case. That would be a proper sort of metaphor or analogy for what's happening here. So on the charter schools, we had an interesting lineup, right? Amy Coney Barrett recused herself because one of her best friends and goddaughter to one of her children, one of her 8 children, was an advisor at the University of Notre Dame to the actual church group that was bringing the case. And so unlike Clarence Thomas and Alito, who would have thought nothing about sitting on the case, she decided, I'm not doing this. So it left us with a 4-4. It left us with an 8-person panel. And why don't you take it from there? And then what happened and what does it mean going forward based on the results, the split results?
Well, I think we can credit her ethical, decision-making basically for recusing herself, because it's up to them whether or not they recuse themselves. They don't have to give a reason. She didn't. She did the right thing here. So because it was a tie, there was no opinion. There was no precedent set. There was no, decision or analysis around whether or not taxpayer money can fund private charter schools, right? That question that was before the court can be brought again, right? There wasn't like precedent set because
there's no majority opinion because there was no majority.
Right. Because it was a tie, it just meant that the lower court ruling stood. So if the lower court ruling was in favor of taxpayer money and we'd had a tie, we'd be in a whole separate boat. But the irony here, and those who've been watching the show, the Oklahoma Supreme Court, right, and the Oklahoma Attorney General was all against funding these private Catholic schools. And so the irony is that the Oklahoma Supreme Court decision is the one that's standing, and that is the one that said no to funding it. So I guess we have Oklahoma to thank here. It's like, everything is like a topsy-turvy, but that's essentially what it is. We will see this come again, Popok, right? They're going to bring this up again in a different way with a different group that's not going to conflict out Justice Amy Coney Barrett. More, but that's okay. We're slowing this down.
Yeah. Look, here's the reality. Roberts switched over and voted with, it's obvious. Roberts did switch and think that, and this is interesting. Roberts switched, finding that this was a violation of the Establishment Clause. It was even a bridge too far for him because he's voted in favor of a lot of religion in public life,
right.
A lot. Prayer by football coaches at midfield and flags and playground equipment and you name it. He sided with it. COVID policies, that type of thing. But here, this was for him even a bridge too far. So he joined the the what I call the moderate or the left-leaning wing of the United States Supreme Court, the Democratic wing of the Supreme Court. And that's how we got the four. The other four, of course, are Kavanaugh, Gorsuch, Alito, and Thomas. The question is, what would Amy Coney Barrett have done? She is a Catholic. It is a big part of who she is. She was a law professor at the University of Notre Dame. That's hence the problem, the issue. She believes in children. She has a lot of them, including adopted ones. How this would have sided with her? Would she have gone establishment clause and sided with Roberts and the liberal wing, or would she have gone with free exercise clause and sided with the others? It's hard. It's hard to know. She has generally sided in favor of religion in public life. So if I was a betting person, I think 60-40, she would have ruled and the majority would have allowed this charter school. Now it's going to have to come back up. Not this case. It's over in Oklahoma for now. It doesn't set precedent as you've laid out, nothing. But in a year or two, depending upon who's still around on the Supreme Court, God forbid Judge Ho, after we talk about him later, a new panel, maybe the same panel, is going to have to talk about it. She's not going to recuse herself. They're not going to make that mistake again using the University of Notre Dame for anything. Because that was they were really kicking themselves that they didn't anticipate that she was going to recuse, because they didn't have to use that consultant at Notre Dame for the there's a lot of other schools out there that are Catholic and law schools. They didn't have to use her, but they did. So that's how it worked out. And we said, because you and I listened to that oral argument, right? You did a preview. You did a preview out of it. We did some post-game show. I had Leah Littman on from Strict Scrutiny. And listening to it, we said, I don't know, the best I think we can get here is 4-4, is Roberts coming over. And I didn't hold a lot of hope up for that. I thought it was 60-40. He wouldn't. But, he surprises me occasionally. Maybe when he thinks it doesn't matter. You know what I mean? Maybe when he thinks it doesn't matter, he's going to go. It's like garbage time in a baseball game or a basketball game. He's like, it's not going to. I'll just side with them 4-4.
I think he's all about incremental changes for the most part. It's why he cited to save Obamacare, don't you think? Because after doing Citizens United, everybody was so up in uproar. He knew that if they also voted against Obamacare, there'd be like an outcry against the Supreme Court. I think he did this. Probably not for any like legal philosophical reason, but trying to kind of save the court. Every time it goes out on a limb, he maybe tries to take it back a little bit because he's trying to not destroy the court, essentially. And it is a good question about Justice Amy Coney Barrett, because I think what she does is look at the case on the facts and the law, this is why she's revolutionary, right? Because we have like Alito and Thomas, like Kavanaugh, like you can just, how they're going to rule just based on, is it about religion or is it about Trump, right? But she tends to really delve more into it. So it might depend on how good of a case it is. So she is harder to predict, but I think you're right. She was appointed to that position because she was going to be pro-Christian nationalist, but she does surprise us. So
yeah. So we'll see, but it's probably 2 years away. The reality, just to put a line under it, 4-4, no precedential value. Oklahoma, it affects Oklahoma because they're not going to get this charter school up and running because there weren't enough votes to do that. It doesn't have any, we won't be able to cite to the case for any other purpose. And I'm sure the alt-right wing Christian right is going to find another case that doesn't have an Amy Coney Barrett problem and just try to lobby Amy Coney Barrett many ways, including ad dollars and different ways that you lobby to try to pressure her into ruling in their favor and allowing religious charter schools. We'll continue to follow it.
Well, just like one quick note on that. I think, though, that the oral argument gave a roadmap to people who do not want to fund religious charter schools, because they made a really good point of the fact that the board that oversaw the schools and over in Oklahoma didn't have any public officials on it. And that was kind of like the linchpin for why they argued that charter schools were not government. And in California, they do have public officials on charter schools. So states kind of have a roadmap. Those who And it seemed like Oklahoma was actually one of them. Those that don't want public taxpayer funding to go to charter schools, start stacking those boards with public officials, and they've eliminated that little loophole that seemed very important to the justices. So in a way, it may have backfired this movement because it announced to all the states where they were going to take this.
How to fix it. That's one of the reasons that we will continue when the new session opens in October. First Monday in October is our start of the next term of the Supreme Court. We will continue this new thing that we started here on Legal AF to make it the home for all things law and politics, which is that we had the live stream of the audio. There's no video at the Supreme Court of the oral arguments. I mean, not every one. There's 60 or 70 oral arguments, but the key ones, we'll do about 10 or 12 a year. Now, could there be, so what happens, just to give people, as we move into our next segment, what happens now, the old term, we're starting to get the last of the opinions. There, some of which have been written, some of which are about to be written. They just argued the oral argument on this like 3 weeks ago, and we already have it. And we already have a decision. So they went very quickly with that because they're trying to wrap up. They're behind because of the 13, 14, 15 emergency applications by the Trump administration and getting their work done. So we'll get those. You and I will be able to talk about 20 more decisions over the course of the summer. And then there'll be, I'm sure, a number of maybe 4 or 5 emergency applications over this summer. Most of which do not get oral argument, but we will be talking about them in depth when they're briefed. There could be, I could see some really momentous issue where they decide they need an oral argument. It's not like they've never had an oral argument. They had oral argument for Bush versus Gore, when they're trying to decide a president. So they control, as you said earlier, they control their own docket. They control their own rules. So we might have an oral argument over the summer. But if we get through the summer with those emergency applications and kind of giving a viewing guide here for the summer on Supreme Court practice, then we'll be sort of in a little bit of a trough after all that comes out in Supreme Court world until the first Monday in October. We'll be able to talk in advance probably around September. You and I will talk about the cases that are coming up. There'll be 10 or 12 cases that we need to keep a close eye on, when they're going to be argued, what they've decided to that interests them, and when they're scheduled for. And then they hold those oral arguments from the first Monday in October until the end of April, beginning of May-ish, and then start issuing their opinions. And we're back and rinse, repeat. Wash, rinse, and repeat, right? Welcome back. You're on Legal AF, the YouTube channel. If I haven't asked you lately, I'm asking you now. Take a minute and hit the subscribe button. And that helps us continue to grow this channel. We got some great contributors. You just met one of them, Dina Doll. I just added this week. It's complicated. No, the edition is not complicated. That's the podcast. It's complicated. Sorry, I got stuttered there. With Renato and Asha. Wait till you see these two former FBI agents, national security experts of the First Order, and they're doing their work now exclusively on Legal AF. And then we also got the Legal AF Substack and the Legal AF podcast. Legal AF, we come in all shapes and sizes for your viewing and audio pleasure. I'm Michael Popok. Until my next report, you're on Legal AF. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states. complaints and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.